So my question to you with this background is, to what extent would you say that the cautious governance in one way or the other? Because obviously I see some practical challenges here where a minister is instructing an officer as Ghana Highway Authority or GES and knows that the person is the constituency or regional chairman of a party and is in opposition. I feel that the court was too reluctant in dealing with this matter. What is your view on that?
My view is very simple. When the court has spoken, that is the law.
That is correct. I agree.
Yes. So I do not have any useful, addition to it.
My Lord, with respect, I'm not asking you to critique. What I'm saying is the basis or the gravamen of my question is the cautious approach. What is your view on this cautious approach to interpretation regarding governance? That's all. I only gave you that example to give a background because you said you didn't understand my question. You get my point now? Very well. Then
Honorable member, my Lord has answered the question that once the court has made pronouncement on the matter, he has no view on it. I think his answer is very clear.
I drew his attention to the fact that I wasn't asking him to critique the decision of the court in the Gojoga Adra case. I only introduced it to draw his attention to the mainstay of my question, because he had come back to say he didn't understand the import of my question. So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case, example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's the Minister of Finance at the time, I think Kwame Poposo, had prepared a budget which was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there, and the then majority said that we are going along with it. And James Mensah said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament? That's
yes.
Rollins 193.
Yes.
And then 196.
Yeah.
So that was the second. My lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court heard that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of recurrence violations of the Constitution, the provisions of the Constitution. So depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy courts. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if it demands that they must be pragmatic, they have to do it. So that is my answer to your question. Thank you.